Please, can you hear me?
Yes, I can hear you. I guess you can hear me now.
Yes, I can hear you clearly.
More or less another legal tussle. Is that not what we are witnessing soon?
Well, you can refer to it as a legal tussle. I think so.
Must we get here?
Okay, so it is expected because law and politics goes together. And um, as you may be aware, or I may have said it severally, that whether we like it or not, the apex court of this country is the political court of this country because um, one of the basic functions of the Supreme Court is to interpret the Constitution.
Yeah.
You will agree with me that the Constitution does not necessarily apply to you and I on a daily basis. The Constitution mostly applies to political leaders and organizations that the state has set up on a daily basis.
Yeah.
And in as much as these institutions have been set up without political uh, lineages, their application and everyday work to work is somehow intertwined with politics. So here you are, we have a Supreme Court whose president, being the former CJ, Madam Gertrude Tokono, who has been removed by a process that we all accept is legal. But when you look at the optics and the lenses, most political watchers are calling it a political action. Okay, now she has been removed and a new person is being replaced to her office. This new person has been appointed by the other side of the political divide, which is now in office as executives. Definitely, the minority is not going to be happy with this, and whatever they will do to ensure that they make it as much as difficult, they will, and that includes what they are doing right now.
Now continuously, we are made to understand that Parliament is an institution which is quite independent from the executive and that of the judiciary. We have also been made to understand that the judiciary is also independent. Now, looking at the article 146, that talks about the CJ's appointment by the president, which is very constitutional, and maybe with a consultation from the Council of State and with the approval of Parliament. Now, one arm of government is exercising its duties. That is, the executive arm of government is appointing a CJ. And now, before the CJ is given that office fully to operate, he has to go through the vetting from one arm of government, which is the legislature. Now, can the judiciary's decision impact what the legislature is doing?
Most definitely. If tomorrow we wake up and the High Court has granted an injunction against the Parliament, Parliament will have no option than to respect the decision of the High Court and halt the vetting. Okay. Now, when it comes to Parliament and the President, when you file an injunction application against them and the court has not moved that injunction application, they will continue to operate until the court has made a determination and firmly told them to stop working before they stop, because the work they are doing is constitutionally mandated. And you cannot stop the work that Parliament is doing by simply filing an injunction application. I mentioned Parliament and the President because I want to draw a distinction between Parliament and the President and then ordinary citizens. Yeah. If you and I were fighting over a piece of land and you filed an injunction application against me from building on the land, the moment you file it and serve it on me, I am supposed to respect that determination, which has not been made by the court. In fact, I'm supposed not to do anything that can deviate from what the court can see. And so at that point in time, I have to stop working until the court has moved the injunction application and decided whether or not I should stop working. Okay. But when it comes to Parliament and President, the rules are quite different. In fact, over the past years, if we look at the precedent, you will notice that anytime that an injunction has been filed against either the president or parliament, they don't stop doing their work. In fact, they wait for the court to make a pronouncement before they will stop doing their work. That is because they are constitutional bodies, and ordinarily, when they are performing their duties, they are not supposed to be impeded until the court has positively told them to stop what they are doing. So when you look at that and you compare it to what the minority is doing, I would just say that, yes, they have a point to make that the CJ has filed an injunction, therefore Parliament must respect it. But in fact and in practice, whenever an injunction is filed against Parliament and the President, they do not stop working until the court has made a determination and asked them to stop.
That there's no legal basis that exists for the minority to push for this decision to be made by the Speaker of Parliament?
I would rather say that their argument is rather far-fetched because it is not supported by the consistent application of the law against the executive and the legislature, which we have seen over the past years that the 1992 Constitution has been practiced. If it was an ordinary person whom an injunction application had been filed against, then the minority would have that basis to say once an injunction has been filed, that person must stop working. But when it comes to Parliament and the executive, it is quite different. And I would dare say that if the minority believe that the vetting of the CJ will constitute a contempt of court, they should test the law by filing a contempt application against the Speaker and the members of Parliament if they proceed to vet the nominee for the CJ position.
Would this case be different? You want to help us here? Looking at what happened last year in the case of whether or not the president was going to assent his signature as far as the law that was passed in Parliament around the LGBTQ plus issues, and some members of Parliament took the case to court, where the Speaker did say that he was going to wait till the determination of the court before some further procedures can be taken. How different is that case compared to this one? If indeed almost same Parliament, even though it's the ninth Parliament, somebody has applied for an injunction, and pending the determination of the court, Speaker moves ahead to ensure that the vetting processes begins.
Well, if you remember very clearly, when the LGBTQ suit was filed in the Supreme Court of Ghana, the presidency decided that it will not accept the bill from Parliament.
Yeah.
But Parliament did not say it will not send the bill to the presidency. In fact, as a matter of fact, the Speaker of Parliament instructed the Clerk of Parliament to ensure that the bill has been sent to the president. And it had to take the Executive Secretary of the President at the time, Nana Santi-Bedier, to write a cease and desist letter warning Parliament not to bring the bill to them because of the Supreme Court, case. That tells you clearly that even in that situation, Parliament and the executive did not agree on what is the position of the law.
Mm-hmm.
Parliament believed that they could go ahead and do their work, as has always been the situation. But the executive at that time rather took the position that once a writ has been filed, they will wait for the outcome of the writ before they take a decision.
Mm-hmm.
And so, respectfully, Parliament forcefully had wanted to, submit the bill to the president despite the pendency of that suit. It was rather the presidency that refused to accept that bill.
So then I would ask, what exactly do the Article 144 and that of 146 imply about the sequencing when removal is contested?
Okay, so in the Constitution, you wouldn't find anything written black and white on when a removal is being contested. Okay, so what we are talking right now, we are simply talking about injunctions.
Yeah.
Okay, And, and in practice, like I've told you, whenever an injunction application is filed against an individual, that individual is expected to respect that injunction, even though the injunction has not been moved and granted by the court. Okay, and there are several examples of cases where injunction applications have not been moved, yet the person went ahead to work and the court cited them for contempt because the injunction application had been served on them. But when it comes to the executive and the legislature, because of the position of the Supreme Court that the executive and the legislature, when they are performing their constitutional mandate, they cannot be injuncted. You would often notice that even when an injunction application has been filed against the executive and the legislature, they still go ahead and do their work until the court has firmly told them to stop doing their work. And it is not only the legislature. Even if I stretch it to other institutions like the Electoral Commission and other constitutionally established bodies, you will notice that anytime someone files an injunction against the Electoral Commission seeking to prevent the Electoral Commission from organizing an election, the EC would normally go ahead to do its work until the court has actually told the EC to stop working. And so it has to apply to those who are performing their constitutionally mandated duty. And in this particular instance, Parliament is performing their constitutionally mandated duty of sitting as a house to vet somebody who has been nominated by the President of the Republic.
Now, the question I would want to also get some clarity on has to do with whether Parliament can adjust its timelines pending litigations. And are there any precedent to that?
There is nothing that prevents Parliament from adjusting its timelines to wait for the litigation. But actually, I would say it will not be the reasonable thing to do, because should Parliament adjust its timelines and the courts decide to drag on for a long time, that would mean that Parliament will not be able to perform its functions as mandated by the Constitution, because nobody, not even the judge, can tell us when the case can be decided, because court cases, there are so many factors that affect how fast or slow the court case can move. And so it will be unreasonable for Parliament to decide that I am adjusting my timelines to wait for the court determination. I don't think Parliament will be willing to do that.
Members on the minority side being political with this issue.
Please, can you ask the question again?
I was asking whether the members on the minority side were asking the Speaker to halt this vetting, whether they are being political, if indeed, per the position of the law that you are explaining to us this very evening.
Well, it is not in my mouth to pronounce whether they are being political or not, because as a matter of fact, we lawyers do not always get the law right. We know the law, but the law also speaks with two voices at any particular point in time. And so maybe they also have something that they believe can work in their favor, and they are trying to exploit it. As a matter of fact, the duty of the minority will not have its full meaning. And so for me, whatever the minority is doing in Parliament, it is their right to do so, it is their duty to do so, and they are not supposed to fail Ghanaians in providing opposition to the presidency and the ruling government.
Now, Council, what is the best path that protects separation of powers and institutional legitimacy?
So it is hard to tell what is the best path. People, scholars like Baron de Montesquieu and others have written thoroughly on these subject matters, but I dare say that none of them got it 100%. If you are looking at a strict separation of powers situation, then probably the best example is the United States of America, where there is strict separation of powers between which is the Congress. And so I would not be able to say which one is the best. But what I can say is that we have come far, 30 years, and fortunately, we are doing constitutional review. if we mean very well about doing this constitutional review, we should be able to identify some of the things in the Constitution which have not helped us and be able to correct them genuinely so that they will help us in future. For example, I have mentioned severally that despite the constitutional guarantees that the judiciary must be independent, when you look at the financial arrangement of the judiciary, I don't think they are truly independent because they need financial clearance from the Ministry of Finance before they can do everything, including employing clerks and secretaries for the judges, including buying cars for the judges, including building new courts and all of those things. I am looking forward to a situation where we either reduce it or increase it. Once we raise the money, that percentage must go to them. Whoever becomes the Chief Justice can now decide on how to manage his department without going to beg the executive for any approval. Then they will become politically independent. Others can look at other aspects of the constitutions and things that potentially detract from the independence of the judiciary and suggest it. And once we are able to push forward some of these reforms and they come to light, I believe our system will get better as we go ahead.
I see. Council, thank you. We're still live on Newsnight speaking with lawyer Richard Eni. He's a private legal practitioner trying to understand what exactly the tussles and the hassles between the minority and that of whether the speaker or the executive is and what the implications are. So then I would ask quickly, with what is currently happening, what can be the implications as far as the vetting of the CJ is concerned?
In my respectful view, unless and until the High Court grants the injunction application of the former Chief Justice, Parliament will not break any law if they continue to vet the Chief Justice nominee. My reason is simple. They are performing their functions under the Constitution. And there are so many Supreme Court decisions that tells us that whenever someone is performing his or her constitutional duties, that person should not be unnecessarily injuncted by the courts of Ghana. And so the courts are very cautious when they are considering injunction applications against bodies or persons that are performing their constitutional duties. Until they grant that injunction application, I want to believe Parliament will be right in proceeding with the vetting of the Chief Justice nominee.
They start the vetting, and let's say they start tomorrow, and the next day, the court goes ahead to determine the case and finally injunct the vetting process. Or what then? Should they stop? Or?
Of course, certainly. The moment the court grants that injunction application, then Parliament will be obliged to stop that vetting process which is ongoing. And so even if they have started already and they did not finish, and the court grants the injunction, they will have to halt the entire proceedings and wait for the matter to come to an end. But until the court has granted it, I believe they have the power and the right to continue performing their constitutionally mandated duty as members of Parliament.
Should they not also go per the Constitution?
In fact, they are going per the Constitution. Per the Constitution, the President is supposed to nominate a Chief Justice in consultation with the Council of State. I believe that is what the President has done. Once the President does his nomination, he is required by law to present that nomination to the Speaker of Parliament. The President has performed that. Once the Speaker of Parliament receives the nomination, it now becomes the Speaker of Parliament's duty to refer that nomination to the appropriate committee in Parliament. And in this particular case, it is the Appointment Committee of Parliament, which the CJ nominee has been referred to. Once that referral has been done, it is the constitutional duty of the Appointments Committee to vet the nominee until any order has been given to them to actually stop. As we speak now, no order has been given to them to stop the nomination. And so they are performing their constitutionally mandated duties. And they have every right and power to vet the Chief Justice nominee and make a pronouncement on him. As we speak now, we do not know whether they are going to pass him or they are going to fail him. And so we have to wait for them to bring out their report. And if they bring out their report and they say they are passing, the president will go ahead and appoint him as Chief Justice. As to when the court will come out with this judgment, we don't know. And Parliament cannot decide to wait until the court finishes with the hearing and the trial.
Now, Council, let me bring you to one issue since we have you as far as minority and Parliament issues are concerned. The minority some few days ago accused the Attorney General of prejudicing cases in the media, and they talked about the fact that he is almost going around pronouncing them guilty whenever he's held before media men and whenever he goes out for a press conference. Are they right to say so? Should the Attorney General continuously do that, or he's expected to wait till the finality of the cases that he's brought before the law courts are known?
Okay, so Mr. Speaker, I'll give you an illustration before I answer this question. In this country, you will agree with me that there are several times that the Ghana Police Service will organize a press conference and tell the whole of Ghanaians that we have arrested, for example, Nana Fianco and Richard Niama. When we arrested them, they were robbing, let's say, Absa Bank. We retrieved 10 pump action machines from their car, and knives, and dagger, and money, and all of those things. And most of the time, at the time that the Ghana Police Service will be doing this press conference and telling the whole of Ghanaians that Nana Fianco and Richard Niama are armed robbers, they have not gone to court. They have only arrested us, and we are suspects. Mm-hmm. It is now that they are going to court to go and get a conviction against us. And it is completely possible that they can go to court and they will not be able to get a conviction against us. Okay. If the police is able to do that and there's no problem with that, then what is wrong with that if the Attorney General is also doing the same thing? The only problem with the Attorney General doing the same thing is that the Attorney General is also a politician. He's a member of Parliament. He's a member of Cabinet. And whatever he does is going to be seen in the light of politics, which is why some of us have said consistently that in order to ensure that prosecutions are going on without political polarization in this country, let us amend Article 88. Let us separate the Attorney General from the Minister of Justice. Let us ensure that the Attorney General is not a member of Cabinet. He is not a politician. He's a professional lawyer who has been appointed by whoever has the power to appoint him, and he can arrest anybody, whether the person is in power or is in opposition, and prosecute them without fear or favor. Until we do that, anytime any Attorney General comes to do something that policemen can do and we shall not talk against, we shall talk against that Attorney General because he's a politician and he did that.
Now, having given us that scenario, let me start from where you started from, with the police and their press conferences, with the things they say, knowing the fact that they will be leading more or less a prosecution charge against the suspects. Should that really happen?
Certainly, it should happen because there are a number of functions that press conference actually plays. Number one, it plays a deterrence role, okay? Sometimes there are some people who believe that, oh, we can do everything and get away with it. But when they hear the police saying that somebody went to do this and we arrested the person, they now become aware or they are reminded that, hey, the police is active. So if I try, maybe I'll also be arrested. That one works. Sometimes they do that press conference in order to be able to get the public to bring more information so that it can even help them to gather more evidence to do whatever they are doing, okay? And I want to believe the Attorney General is also trying to achieve similar objectives. Even in the case of the Attorney General, he is an elected official under the ticket of the NDC. And whether the NDC like it or not, Ghanaians are going to judge them by the same things they came to tell us before we voted for them. We didn't tell them that they should come and do ORA. They are the ones who came and told us that they want to do something ORA, something called ORA. So if they are not able to tell us that they have been able to do the ORA, we have every right to punish them in the next election. And I believe that is what the Attorney General is seeking to do as a politician, which is why naturally the minority will not be happy about, because assuming without admitting, I'm not saying they have succeeded with ORA, but assuming that the NDC succeeds in executing their promise of ORA, then it means it is dwindling the chances of the minority in coming back into parliament as majority. So there's a political dynamics over there, but legally, I can say for a fact that an ordinary lawyer like me, I'll be called before the General Legal Council if I went out and organized a press conference and told the whole world that Nana Fianco is a thief, when Nana Fianco has not been judged as a thief by any court of competent jurisdiction. I will be called before the General Legal Council because I'm an ordinary lawyer, okay? But as we speak now, you can't hold the Attorney General before the General Legal Council. He's actually a member of the General Legal Council. So you appreciate the reason why some of us have been advocating that.
Okay.
That
so counsel. So what it means is that you are a lawyer. The Attorney General is also a lawyer. What you will do, and you'll be held before the General Legal Council, the Attorney General will do same and will go scot-free.
Certainly, because he's a member of the General Legal Council. In fact, when they are about to call new lawyers, it is the Attorney General who normally gets up to move the motion for new lawyers to be called and enrolled into the register, okay? So certain things that an ordinary lawyer can do and get punished for, it will be difficult to punish the Attorney General. Don't forget, he's also the legal advisor of the government, and he's leading the government legal agenda. And so if the government has promised that they want to do ORA, and the man is saying, I'm coming to update the country on how ORA has performed, how then do you drag that man to the General Legal Council? So if we really want to separate the law from the politics.
All right, Counsel, most grateful for your time on Newsnight this evening.
You are most welcome, Mr. Speaker.
Well, that was a private legal practitioner, lawyer Richard Niama, taking us through some legal gymnastics, some legal tutorials, helping us understand the position of the law as far as Article 144 and 146 vis-a-vis the position taken by a minority asking the Speaker of Parliament to halt the vetting